Today we are starting Arbitration and Conciliation Act 1996. So the year you have to remember it, 1996. Okay. Now Arbitration and Conciliation Act 1996 was enacted on 16th August 1996. Date and all that it is not necessary. If the act is 1996, most probably it is enacted in 1996. Sometime it might have enacted in 95 or something like that. Might have been notified in 96. That is also possible. But that all that you just understand how the law comes. The law might have been enacted, but it has to be signed. It has to be notified. And some of the time there will be a provision that certain provision will come into effect from certain date. Some other provisions will come from some other date. For example, Companies Act. It has come in 3 different days. And some more sections are not. Today also 2030 is not applicable. 1956 applicable. So they will be notifying these sections are applicable from so and so date. But as far as this act is concerned, which act? Arbitration and Conciliation Act 1996 came into effect on 16th August 1996. But it got, normally acts will not have retrospective effect. But this act got retrospective effect. It is 25th January 1996 onwards. Application all over India. This is applicable all over India. So, as we discussed earlier, certain acts are not applicable in Jammu and Kashmir. Certain other acts might not be applicable in certain place. Normally, it is applicable all over India. In certain cases, it is not applicable. But as far as Arbitration and Conciliation Act is concerned, 1996. Here, there is two words are used. One is arbitration, another one conciliations. Arbitration, according to that, if the arbitration tribunal is going to give, so they are going to appoint two persons or 3 persons, and they are going to decide. That is called arbitration award. That is enforceable by law. But conciliation is concerned, there might not be any contract, but the parties will be sitting in the with the help of somebody and try to find out a solution. Somebody will conciliate. They will say that this is the case and all that, but it is not binding on them. If they want, after the conciliation is concerned, they can enter into a settlement. If they don't want, they need not enter it. Or one of the party is not interested in conciliation, he need not enter it, because there is no written agreement. But as far as arbitration is concerned, there will be a written agreement. All these things we will discuss after some time. Okay. Now, arbitration is an alternate means of settlement of a dispute in place of approaching a court. You have a dispute. 2 persons are having a dispute. How to solve it? They have to go to the court. That is a normal procedure. But nowadays what happened? Cases are pending in the courts for 5 years, 10 years and all that. It takes lot of time. Not only all over India it is a problem. So that is a thing. So what is that? It is alternate. What is that alternate? It is arbitration is alternate going to the court's assistance. You will not go to the court. You go to the arbitration. That how to create an arbitration tribunal, will come to that. However, this does not amount to working out of a compromise between. It is not a compromise. What it say that arbitration is not compromise. It is not decided by the court, but it is decided by the arbitration tribunal. But it is arbitration award is based on substantive law. What is a major act? For example, it is a property dispute. So whatever civil law is that will be indirectly applied. So substantive. What is a substantive? In the case of income tax, how the salary will be charged, charging section and all that, that is called substantive. Filing the return and all that, some of the things are procedural. So here it say that arbitration award is based on the substantive law. So what is the law? That will be kept in mind by the arbitration tribunal. What is the arbitration tribunal? Persons appointed by both the parties who are in the having a dispute. So they will take into consideration of the law as such. Not like a lawyer, the court, they will discuss everything, but they will keep it in mind. For example, 2 sons are there. One son says that I am entitled for full property. Another son says no, I am entitled. Most probably they will know that as per the Hindu law, both of them might be entitled for 50% of the property. Correct? So most probably the arbitration award also will be like that. So they will take into consideration of the act. It is not that compromise. It is okay, you take this much, you take this much. Not like that. They have to consider all aspects and they have to decide. Who will decide? Arbitration tribunal. Who is that? What is that arbitration tribunal? The persons appointed by the litigants themselves to arbitrate. So, okay. So arbitration is who can appoint? Anybody can appoint the arbitrator. Say if there is a agreement, we will come to that. If there is an arbitration agreement, the arbitration can be referred by individuals or society, company, all of them can do that. It is not only for company. It is for everybody. Whoever is entered into a contract with somebody, there is a provision that it has to be referred to arbitration. It can be referred to the arbitration tribunal. So individuals also can do it, partnership also can do it, society can do it, limited liability can do that, partnership can do that. All of them, whoever can enter into a contract, they can refer the matter to arbitration also. There is no restriction as such. Some of the matters cannot be referred to arbitration. That we will see that. For example, criminal activities, that cannot be entered. Or divorce related things, that cannot be referred to arbitration. Husband and wife cannot refer to a arbitration tribunal. You decide, no, that court has to decide. So certain things cannot be entered, but there is no restriction as far as persons are concerned. Anybody who has entered in a contract, there is a provision regarding arbitration, they can enter it. Okay. Now, Arbitration and Conciliation Act provides the details of all matters related to arbitration. How to conduct the arbitration? Everything is contained. It is not, say, for example, what we told in the case of Transfer of Property Act, two things are supplementary. That is Contract Act and Registration Act. But in this, it is more or less, it is self-contained. About the arbitration, Arbitration and Conciliation Act contains everything. Okay. Now, the present act is based on model law drafted by United Nations Commission on International Trade Laws. There is a United Nations, they have various committees or commissions. One commission is called United Nations Commission on International Trade. What is that? United Nations, that is a UN. They have a commission appointed. For what purpose? On international trade law. So they came out with this model, they both on domestic and arbitration as well as international commercial arbitration. They have come out. Who has come out? United Nations Commission on International Trade. To develop the international trade, there is a commission. They got a United Nations. They have come out model law for domestic arbitration and international. That is applicable to all that. All the countries, they can subscribe to that. Most of the countries, they have subscribed. That is followed. For example, what is a law for domestic? It is applicable in India if it is both the parties on India. So more or less same model law that America might have, US might have adopted. So that is applicable in states also. But one person is in, one party is in India, another party in Pakistan. Then international, that is called international arbitration. Because it is more, one of the parties staying in another country. That is one. Another one you have to remember that arbitration need not be between two parties. It can be many. So if it is a business contract, you will think that one person will give the contract, another person will do all that. It is normal. But in many cases, 3-4 parties might be there. For example, family property matter, even 10-15 people also can be there. All the brothers, sisters and all that might be that. So there is no restriction. How many people are required? At least, say if there has to be a dispute, what is required? 2 persons are. So that is why Swamis go and stay alone. Then there will be disputes. They will be free. They can think about other things and all that. Like that, 2 persons are required, but there is no restriction as far as number of persons who can be involved in arbitration. Object of arbitration is settlement of dispute in an expeditious. What is expeditious? Speedy, very quickly. But as I told you in Consumer Protection Act, if you go to the court, it takes a lot of time. So that is expeditious, convenient. Why it is convenient? It is decided by the arbitrator after listening, taking the particular information from both the parties and going through the document. They complete it within a short time. And so it is convenient. They need not engage very senior lawyers and all that. That is one. For example, if 2 parties are there in Madurai, the court is in Chennai, so they have to come very frequently. But if it is arbitration, they can have the arbitration will take place in Madurai itself. That can be decided, it will be in Madurai. Something like that, it can be that. Okay, it's convenient. inexpensive, because it is going to be decided in short time, and you are not going to engage many lawyers and all that. It is inexpensive. Okay. So as such, no, when you are appointing a arbitration members for the arbitration tribunal who will decide, most probably you have to pay some fees, and you might be having somebody to explain the things to the arbitration tribunal. You have to pay some fees. So that fees will be there, but it will be comparatively, it will be less. So it says that inexpensive. Why people are going to have to go for arbitration? Expeditious, convenient, and inexpensive. Private manner, so that they do not become the subject of future litigation between the parties. For example, if you go to the court and you are having a case listed and it is heard in the court, everybody will come to know you two persons are having problem, correct? But if it is arbitration, no other person will be there. Who other persons will be there? Only the litigant, two litigants will be there. Most probably somebody to represent them. With them somebody might have come. They alone will be allowed. So outsider will not come to know that there is a dispute between these two people. So sometimes what happen, if somebody comes to know that about a particular property there is a dispute, what will happen? The property will go down. So like that, so many things are there when public comes to know. So here the public will not, it is a private manner it is being under. So these are the 4 reasons you have to write. Okay. Certain matters which are not arbitrable, you cannot refer these matters to arbitration. Suits for divorce or restitution of conjugal rights. What is divorce? Say two people want to divorce, husband and wife, or restitution of conjugal rights. Husband and wife left the other party and they are living alone. So other party goes to the court saying that please tell that person to live with me. That is called restitution of conjugal rights. That cannot be referred to arbitration. Taxations. So taxation cannot be referred. Recently what happened, I don't know whether you read it or not. Vodafone wanted to refer the matter to Vodafone. There is a very big 10,000 crore, more than 10,000 crore tax dispute is there. They want to refer to arbitration. Why that? Because of that is the double tax avoidance treaty. There that might be a possibility that government of India and other party can refer to arbitration. But in India, a taxpayer cannot ask the government, we will go for arbitration. What we have to do that? We have to submit all our information to the assessing officer. He will decide it. If you are not satisfied, you will go for appeal. If you are not satisfied, you will go to tax tribunal, appellate tribunal. Then if you are not satisfied, you may go to High Court, then Supreme Court, like that. But you cannot say that, sir, you cannot tell the government, now we will go for arbitration, taxation matter, non-payment of admitted liability. So there was a case is there and he agreed that he has to pay 1 lakh rupees. Afterwards he is not paying that. So once again you cannot go for arbitration because already admitted liability, non-payment of admitted liability. So if somebody is not paying and you refer the matter, it is reduced. Then once again he is not paying, once again you reduce, then his money will be going down. So non-payment of admitted liability you cannot refer. Criminal matters you cannot change. So these are, now might be some 1 or 2 in another acts also might be that. These are the important thing. What is that? Suits for divorce or restitution of conjugal rights. That is living together. Or marriage, whatever benefit there. Taxation, non-payment of admitted liability, criminal matters. These are the 4 items cannot be referred to arbitration. Then section 5 of the Act clarifies that notwithstanding anything contained in any other law for the time being in force, matters governed by the Act, judicial authority can intervene only as provided in this Act, not under any other Act. So Arbitration Act say that these matters can be referred to arbitration. They have got a contract also, it can be entered into the contract. Now somebody wants to go to the court, court should not entertain. Even some provision is there, some other act. What is that? It is overriding effect. Whatever there in other acts, arbitration acts overrides. What is the meaning of that? If the arbitration act say that this can be referred to arbitration, in some other act, some other provision is there, that is not effective. What is effective? What is there in arbitration act? So that is, once again I will read it because it is a legal term, so you have to remember it. Right. Notwithstanding anything in contained any other law. It is called non-abstante clause. So that is a very important. In income tax, many places it will say that whatever contained in other section, notwithstanding anything contained in other section, this is applicable. So like here what is that? Notwithstanding anything contained in any other law for the timing in force in matters governed by this act. Which act? Arbitration Act. Arbitration and Conciliation Act. Judicial authority can intervene when only as provided in this act, not under any other act. So if this act is there, it is to be referred to arbitration, that is end of it. As that sometime what happened, if the arbitrator has not applied his mind proper, he without the natural justice is not followed and he has given the arbitration award, then the court may intervene. Otherwise, court has no say at all. If the matter is referred to arbitration as per the arbitration agreement, or it is going to be referred, court has no say at all, unless there is some specific problems. So that also we will discuss after some time once again. Act is divided into following parts. Part 1, domestic arbitration. Both the parties, all the parties in India, that is called domestic. That part 1 deals with all that. Then part 2 deals with enforcement of foreign awards. What is the meaning of that? One Indian might be there, one foreigner is there. That arbitration, according to the agreement, it is to be referred to arbitration in UK, but that is London. That has been entered, and London arbitration tribunal has given that Indian who is one of the party has to pay 5 crore. Now how to recover 5 crore? It is to be recovered from India because he is in India and another party in UK. But the agreement says that this, if any dispute is there, this arbitration is to be referred to somebody in London, not in India. So arbitration tribunal will meet in London, they will give the award. Now that award can be submitted to the court in India, court will enforce it. That is called enforcement of foreign awards. Clear or not? So it is decided in some other country, but it affects somebody in India. He has to make the payment. How to recover it? You refer to the court, court will help you to recover it. So that is part 2, enforcement of foreign awards. Conciliation proceeding. Say award is different, conciliation is different. That will come to know afterwards. Okay. Now part 4, supplementary provision. For all the 3, some supplementary provisions, how to meet and all that type of things are there. Then first schedule, Convention on Recognition and Enforcement of Foreign Arbitral Award as per New York Convention. So that was their meeting was there in New York. They have decided in the case of foreign award is recognition and enforcement of foreign arbitral award. What is that award given in London? How to be enforced in India? That is decided in New York Convention. New York. What is the meaning? There was a meeting of experts from all over India, all over the world. In New York, they have decided. So all the countries have been represented. They have decided. That is called New York Convention. They have given some guidelines how to recognize and the enforcement of foreign arbitral award. Then second schedule contains then protocol on arbitration. What are the requirements for each clause? Third schedule, Convention on the Execution of Foreign Arbitral Award as per. So first one is recognition, second one enforcement, that how to execute that award. These are the things. But we will not go into the detail of very much about the foreign, but we will know what is a foreign award and all that. That is arbitration. What is the definition? Section 21A of the Act defines a term arbitration as to mean any arbitration whether or not administered by a permanent arbitral. So arbitration definition is not defining. What is arbitration? If two people have some difference of opinion due to law or any other reason, they can refer to some other person. That is called arbitration. Okay. Now the term arbitrator is not defined in the arbitration and conciliation. Why this arbitrator is important? Because the persons who are having dispute, they are referring to somebody. That somebody is called arbitrator. Most probably both of them will appoint one and both of them together will, that new arbitrator, two arbitrators, they will appoint one more. So 3 people arbitrator will be there. Or what happened, the agreement, arbitration agreement may say that both of them should jointly appoint one person. then second, third persons will not be. So what happens? The persons who are disputing, they themselves will decide who is going to be arbitrator. Both of them will discuss among themselves and they will tell that we will appoint this person, then they will give the letter. So arbitrator is not defined in the Arbitration and Conciliation Act, but arbitrator is a person who is appointed to determine differences, disputes between two or more parties by their mutual agreement, consent. So it is mutual consent. Agreement, arbitration is concerned, nobody is compelling them to go for arbitration. So they themselves decide arbitration. When to enter into agreement, we will discuss after some time. Then it is not enough that parties appoint an arbitrator. If they appoint an arbitrator, that is not end of it. What is the requirement? The person who is so appointed must also give his consent to act as an arbitrator. So A and B has decided Mr. X will be the arbitrator. They communicate, nothing happens. Arbitrator not appointed. When that will come into that, when Mr. X say that I am willing to work as arbitrator. So it may not be so many words, but he has to tell that he is willing to act as arbitrator, then arbitrator has been appointed. Now, his appointment is not complete till he has accepted the reference. He has to accept it. The arbitrator must be absolutely disinterested, impartial. Disinterested means it is not that he is not interested or something like that. In that dispute matter, he should not be interested, or he should not be related to one of the parties. Okay, if he is related to one of the party and all that, he should inform both the parties, I am related to so and so party, I am a partner of so and so party. Then they will decide whether to appoint or not. So the arbitrator must be absolutely disinterested and impartial. So what is that? Judges also has to be impartial. What they have to do? They have to collect the fact, they have to analyze the act, law, accordingly they have to decide. There should not be partiality. Partiality means favoring one person. That is not, that is called impartial. Okay, he should be a man of impartial. Then, he is an extrajudicial tribunal whose decision is binding on the parties. Why it is called extrajudicial? It is not appointed by the state. State means not only state, central government. So, the government is called state in English. But in India, we have separate state government, central government and all that. So, the arbitrator is not appointed by the government. He is a extrajudicial. How he get that power? Both the parties are appointing him as an arbitrator. Okay. Then, section 10 of the Act provides that the parties are free to determine number of arbitrators, provided that number shall not be an even number. What it say that? They can appoint, that agreement can say that both of them will appoint one or something like that. But it say that they can decide any number, but it should not be true. If it is true, what they will do? Both the arbitrator, two parties are disputing, both of them appointing one as per the agreement. Then the agreement will say that both the arbitrators will appoint third arbitrator. Now what happens? So three persons will become. Why it has to be not to be in even? Because then each one decides differently. Then there will be no end to it. So third person has to be there, or only one person has to be there, or 5 persons, something like that. It is possible. Okay, if they fail to determine the number of arbitrators, tribunal shall consist of a sole arbitrator. So they have a dispute. Now arbitration agreement says that they have to appoint the arbitrator. Now they have another dispute. What is the dispute? Whether they have to appoint 1 or 3 and all that, they have a dispute. If they are not appointed like that, what happens? Only one arbitrator is required. That also they have to appoint. So they have a dispute about the original matter. Now they have a difference of opinion about appointment of arbitrator. Then also the arbitration agreement is valid, and there one person will have to be appointed. An arbitration agreement specifying even number of arbitrators would not be a ground to render the arbitration agreement invalid under that. MMTC Limited versus Sterlite Industries India Limited. What is the meaning of that? One in this particular, it is a Sterlite. It is one of the very big company in India. MMTC Mineral and Material Trading Corporation. They import the material and all that, mineral and all that, a foreign country, and supply to various that. They are called canalizing agency. They will be importing from foreign country bulk material and they will distribute. That is called MMTC, Metal and Mineral Trading Corporation versus Sterlite Industries. In that case, what happened? It says that even though arbitration agreement is about the number of specifying even number, it says that each one will appoint 2. Then one of the parties say that this arbitration is not valid. What the court held? It is valid. Even if the arbitration agreement say that one person to be appointed, totally 2, then also it is not invalid. It is valid. What they will do? Both of them together they will appoint one more person. All the 3 will be deciding. So one thing you remember that all the 3 will have equal vote. The person who has been appointed by the 2 arbitrator, he is not different from the arbitrator who appointed. Because 3 arbitrator means all the 3 arbitrators will have same power and all that. There will be no difference. Okay. Now, ground for challenge. So, arbitrator has been appointed. One of the party wants to go to the court. Say, for example, Jayalalitha delayed the case for 10-15. I don't remember what is that. The case decided in Bangalore. He decided, delayed for 15 years or something like that. Likewise, here also in the arbitration, one of the party who thinks that it will go against him, he will like to delay. Now what happened? Arbitrator is appointed. He will go to the court. I don't agree with this arbitrator who has been appointed. Please set aside. Then the act says that when it can be challenged. Challenge means this arbitrator is not fit to be arbitrator. Like that, it can be challenged. Okay. Circumstances that give rise to justifiable doubts as to independence and impartiality. What it says that circumstances exist that give rise to the justifiable doubts as to his independence or impartiality. So the circumstances are that we will think that he will not be impartial or he will not be independent. We have to prove to the court he will not be independent. What is the meaning? He will do the work. The circumstances exist that give rise to justifiable doubts as to his independence. Whose independence? Arbitrator's independence. One party believes that he is not going to decide on his own. He will follow the instruction of the other party. But if he can prove to the court, he can go to the court saying that this arbitrator appointment has to be cancelled. That is called challenging the appointment, or he will not be impartial. So just don't bother about that. How the court will decide and all that. They will take into consideration all the facts and all that. They will decide. What you have to know now, when the appointment of the arbitrator can be challenged, when the prima facie on the basis of that there is a doubt, he will not be independent or he will not be impartiality. He will be partial to somebody. If you can prove to the court may set aside the appointment of the arbitrator. This person is not suitable to be arbitrator. Please appoint another arbitrator. So this one possible. Then he does not possess the qualification agreed to by the parties. So it is a financial problem that was decided that one chartered accountant will be appointed as an arbitrator. But they have appointed a person with pre-com qualification as practicing as accountant. So he is helping the companies to have the accounts and all that. So another party can go to the court. This person, according to the agreement, according to the law, no qualification is there. But according to the agreement, who has to be appointed? One chartered accountant has to be appointed. But whom they appointed? They appointed a BCom graduate. So other party, after appointing comes to know, he can go to the court saying that he should not continue as the possible. Or there is a quality dispute about the chemical supplied by the supplier to the company. Okay. What is that? One supplier has supplied 1000 tons of one particular chemical to manufacturing company. There is a dispute about the quality. And contract says that one person who has worked within this type of companies for 10 years has to be appointed as arbitrator. Why 10 years experience? Then only he will be able to know whether there is any quality problem. But they have appointed a person without experience. So other party can go to the court saying that this person is not qualified in worked in a company for 10 years. So he is not capable of analyzing it. So cancel that. That is also possible. Second one, he is not possessing the qualification prescribed, agreed by the parties themselves. Okay. Okay. So the challenge is also permitted if a party becomes aware of these grounds after an appointment is made. Say before appointment, all these cases the other party can go. He has been appointed. This person also agreed. Both of them agreed. Okay, both of them agreed. Afterwards, one party comes to know that he is not having 10 years experience in chemical factory. Then he can object. He can go to the court. So before appointment, he can object, go to the court. And after the appointment, if he comes to know, say at the time of appointment, he is not knowing that he has not worked for 10 years in the chemical factory. Okay, appointed. Afterwards, he comes to know. Now he can go to the court saying that we appointed this person, but he is not qualified because he has not completed, he is not having 10 years experience. So this is also possible. Okay.